I'm going to call the March 29th land use hearing to order. Ladies and gentlemen, my name is Dan Dorn. I'm the Umatilla County Chair. Our role today is to conduct a public hearing concerning a request to establish a new aggregate site. Add to the site to the Umatilla County Comprehensive Plan list of Goal 5 protected large significant sites, and apply the aggregate resource overlay zone to the entire quarry site. I'll begin the hearing today by asking staff to summarize the application. I will then ask the applicant to testify, followed by those in favor of the application. Then any persons in opposition or who have questions or concerns will also have a chance to speak. I do want to give everybody notice that we'll hold testimony to 10 minutes and that you will be given a 1-minute warning, and then with questions and comments, we'll go from there. If there is opposition or questions, staff may respond to them. I do ask that all questions, comments be directed to me, and then I'll handle them to the staff. The commissioners may also ask the staff and witness questions throughout the hearing until the record closes. Any person with an interest in today's agenda may offer relevant oral and/or written testimony, but please only speak when I identify you for that purpose. When you testify, please begin by clearly stating your name and address. If you represent someone, please say so. If you have any exhibits you want us to consider, such as a copy of your testimony, photographs, petitions, or other documents or physical evidence, please provide them to me. It will be marked as part of the record. That's the formal statement. The informal statement is land use hearings can be adversarial. There is no doubt about it. Not in every case, but in some cases. I want to make clear today that there will be zero tolerance for personal comments, personal jabs at each other or at counsel or at consultants. We are here to listen to testimony that parallels the criteria that staff have had to use to determine today's outcome. So please understand there will be zero tolerance at any kind of personal interaction or jabs or negative comments, personal negative comments. At this time, I'll ask staff to begin the show.
Good morning, Commissioners. My name is Megan Dovchevsky. I'm the Planning Division Manager in the Community Development Department. The request before you today is regarding a proposed Goal 5 Post Acknowledgement Plan Amendment, or a PAPA request for short. The applicant requests to establish a new aggregate site, add that site to the Umatilla County Comprehensive Plan list of Goal 5 protected large significant sites, and apply the aggregate resource overlay zone to the entire quarry site. The property is comprised of several tax lots and is approximately 225 acres and currently zoned exclusive farm use. The subject property is south of Interstates 82 and 84 interchange, southwest of the Westland Road interchange, and south of Stafford Council Road. The proposal, if approved, would add this site to a large significant site onto the county's Goal 5 inventory of significant sites. The applicant desires to excavate aggregate, batch aggregate for various commercial and industrial projects, stockpile unused aggregate material for current and future use, and process the aggregate into both asphalt and concrete. Both sand and gravel materials are available on the site. The criteria of approval are found in Oregon Administrative Rule 660, Division 23, Sections 40 through 50, 660, Division 23, Section 180, subsections 3, 5, and 7, and Umatilla County's Development Code Sections 152, 487 to 488. The County Planning Commission held a public hearing on this matter on Thursday, October 20th, 2022. Testimony was provided by the applicant and their consultant and several project opponents, including neighboring property owners and nearby aggregate operators, and a representative from Oregon Water Resources. Several documents not included in the original October hearing packets were introduced into the record and are included as Exhibits A through E. Upon request from the applicant, the Planning Commission continued the hearing to Thursday, December 15th, 2022. The applicant's request for a continuation was due to issues raised by neighboring landowners and other aggregate producers. Subsequent to the October hearing, additional information was submitted by one opponent of the amendment, as well as the applicant and Oregon Water Resources. These documents were added to the project record and are included as Exhibits F through J. Upon request of an opponent, the Planning Commission continued the hearing again to Thursday, January 26, 2023. The opponent's request for continuation was due to new information that was presented at the December 15th, 2022 hearing. Additionally, the Planning Commission left the record open for 7 days for new evidence, 7 days for rebuttal, and 7 days for the applicant's final legal arguments in accordance with ORS 197-763. The continued hearing on January 26, 2023 was not to include evidence outside of the 777 timeframe, nor allow for new testimony. In accordance with the Planning Commission's decision for a continuance, additional documentation was added to the record and is included as Exhibits K through P. The process of approval by the county involves review by the County Planning Commission with a recommendation to the Board of County Commissioners. Public hearings were held before the Planning Commission on October 20th, December 15th, 2022, and January 27th, 2023. On January 27th, the Planning Commission, with a 7-1 vote, recommended approval of the Girth Dog PAPA request to add the proposed site to the county's list of large significant resource sites, apply the AR overlay zone, and approve the site for aggregate mining. The recommendation included a modification of subsequent condition number 2 and the addition of subsequent conditions numbered 8 through 13. Subsequent condition number 2 was modified to include this statement. Access to the mining operation shall be restricted from Stafford Hansel Road. Processing equipment shall be located at least 500 feet from existing dwellings, shall be located on tax lot 1800, and placed in the pit once open to the finished depth. Processing equipment shall remain in this location for the duration of the aggregate operation. Subsequent conditions number 8 through 13 are located on page 36 of the preliminary findings or page 44 of your packets today. Subsequent to your packets being created, there were 2 additional comments that were submitted. The first should be entered into the record as Exhibit Q, which was submitted March 24th by Sarah Stoffer Curtis, who represents the applicant. And the second should be entered as Exhibit R, which was submitted on March 28th by Andrew Stamp, representing several opponents. These materials were provided to the board as soon as they were submitted to the planning staff. In conclusion, the Board of Commissioners must also hold a public hearing and decide whether or not to adopt the proposed amendments. The board may decide to accept and adopt the Planning Commission's findings and recommendation, or determine new findings with a decision to approve or deny the post-acknowledgement application request. The board's decision is final unless timely appealed to the Land Use Board of Appeals. This concludes the staff report. Unless there's any questions.
Thank you, Megan. At this time, I'd call for abstentions, bias, conflict of interest, declarations of ex parte contact, and objections of justification.
Okay.
Jurisdiction.
I'm Cindy Timmons, County Commissioner, and I understand this is a new hearing. I was a Land Use Commissioner on October 20th, 2022 during that proceeding. But I'm here now as a Commissioner and realize this is a new hearing.
Thank you, Commissioner Timmons. Following declaration is required to be read prior to the beginning of the hearing. We'll get started in just a second. The agenda identifies the applicable substantive criteria for evaluating the request. Staff will review these criteria. All testimony and evidence must be directed toward this criteria. Failure to raise an issue with sufficient detail to afford the decision-making body and the parties an opportunity to respond to the issue precludes in an appeal to the Land Use Board of Appeals based on that issue. So we'll begin the hearing. At this time, I'll call for proponents, applicants, and/or representative.
and address, please.
Chair Doran, Commissioner Schaefer, and Commissioner Timmons, congratulations. Carla McLean, for the record, of Carla McLean Consulting, address is 170 Van Buren Drive in Umatilla. I'm here representing Craig Coleman, Girth Dog LLC on this application.
I'm Craig Coleman, I'm the applicant, 71888 Wilson Lane, Boardman, Oregon, 97818.
So we just want to adhere to your 10 minutes and summarize briefly the letter that Sarah Stauffer Curtis submitted last week on behalf of the applicant. Again, the proposal has been restated by staff. It's clear. The law that is applicable is, we've seen it before. Aggregate is a common activity in rural Eastern Oregon. We're simply asking for the same consideration that others have in that respect. A number of issues have been raised through the hearings. The letter addresses those. I think that the points that we want to make is that issues related to commercial need are not relevant to the year review of the application. And we're all interested in what the market's doing, but it's not a consideration of a land use decision. Issues related to other potential aggregate sites are not relevant to the county's review of the application. This is in particular to property to the west of this site that has been deemed significant by the county back in the late 1990s, but was not approved for mining. The surface rights and the mineral rights are owned by different parties. The application that Mr. Coleman has submitted is actually more comprehensive than other recent sand and gravel applications. Included is a traffic analysis and additional analysis based on the issues raised. There are other state standards that are applicable and will be applicable to this process as the applicant continues to move forward once land use approval is achieved. I think that's a clear marker. In Oregon, state agencies are required to follow a state agency coordination process, and land use is usually the first process to kind of go through the steps. Following will be dogamy and DEQ and water resources. Those issues will follow. The applicant is fully aware he needs to comply with those and has every intention of doing that. To that end, there's a letter in the record from Bill Porfili, a local water rights adjudicator, and he indicates the process, indicates that there is water available, but it does have to go through a process, and we anticipate that to happen. And once we have this land use approval in hand, those steps will begin, along with the DEQ permitting and the dogamy permitting. And then not only does the county, but those agencies also continue to have review and input into the activity that will happen once the operation is up and running. So DEQ compliance, dogamy compliance, compliance with county conditions will continue. There's been some question about the site and where mining will start. We did provide a hopefully a more clear site plan. Initially, we're going to dig a hole. The hole will be in about the first 10 acres. Outside of that hole, we'll place the equipment temporarily. It will be on ground level. But once that hole is built, the equipment will be moved into that hole and will stay in that site as required by the county approval, the recommendation from the Planning Commission for the life of the pit. The things inside of that hole will be the concrete plant, the asphalt plant, the stockpile sites, and the crusher sites. We also provided in our final submittal just some information around the other state agencies and what their roles are, as well as the compliance issues that would be applicable. I hope I'm well within my 10 minutes. Be happy to answer any questions you have.
Commissioners?
I have a lot of questions, but will we have questions later on down the line? Okay.
Sure. Mr. Coleman, comments?
I think Carla summed it up pretty well. In the process that this has been a learning experience in this permitting process. It's been kind of fun, actually. What we found out is most of the opposition came from competition. Actually, pretty much the people that are opposing it are definitely.
Make sure we stick to the criteria.
Oh, okay. Well, that's about it. We're trying to do everything that we're supposed to do. And Carla has worked, Carla has done this before, so we engaged her because she has a track record of applications. I think you've done 4 of them now. And that's about it. We're just trying to get this thing passed and away we go.
Thank you, Mr. Coleman. Anything else, Carla?
I don't think so. Again, when you're ready for questions, we'll do our best to answer them.
Thank you.
Thank you.
Additional proponents of the application? Seeing none?
Please.
Oh, there you go.
There's me anyway. You want to come sit
Yes,
down?
please sit down and state your name and address, please.
Jeff Hines, I'm with H&S Incorporated, I'm a rock producer. Address is P.O. Box 322, Echo, Oregon, right now.
Yep, you're good.
I met Craig and Bob Coleman a couple of years ago and went through this process, and it's been interesting. Like he said, one of the things that I'm a rock producer, but I'm also in the contracting business. And since I've moved to Umatilla County, I have acquired several jobs. And the jobs I've acquired are several with Amazon. And some of the Amazon projects are going on. They have approached me for rock. And the existing rock people that are producing rock now have given them prices, done whatever, but they've approached me. And so I have worked with, in Morrow County, with a company that we've hauled rock to Umatilla County. We're hauling rock currently to Morrow County now and using these sources. The sources that we're using are quite some distance further from Boardman, Oregon, where there's a lot of work going on. So we're burning more fuel, we're going through bigger steps. This particular rock source that Craig and his son are opening or like to open is closer to these projects where this rock is needed. And the reason why I've become involved is because they recognize that I was doing a lot of these projects, and they've asked me to be involved with them. And the biggest thing that I really liked about what has come up in the last 2 years with these 2 gentlemen I've met is the son asked me a few months back, he said, can we farm in these holes when we're done with them? And I thought, wow, nobody ever asked me that before. And I said, I don't know why not. You're the farmer. I said, we can give you enough ground. So that's been a big opposition. Well, we're taking up farm ground, taking good farm ground. Well, they have every right to control that. And I really liked that question. Can we farm these when we're done with these holes? And then I said, I don't know why you can't. And they do grow a lot of different kinds of crops that most folks don't. So anyway, but I am very much for helping these 2, and I'm helping myself at the same time.
Thank you, Mr. Hines. Questions? Thank you.
Thank you.
Additional proponents? Seeing none, I'll call for opponents. Anyone opposed to this project? Please state your names and address.
My name is Wade Aylett, 75134 West Oregon Lane, Oregon 97844.
Good morning, honorable members of county court. My name is Andrew Stamp, representing Wade Aylett, Rocket LLC, Rock Solid Sand and Gravel. For the record, my address is Val Fotheringham, 17355 Southwest Boones Ferry Road, Suite A, Lake Oswego, Oregon 97035. I'm going to go ahead and start. My primary theme to the Planning Commission, which I'll repeat here, is that the application simply does not provide enough information to meet the approval standards and have that information be supported by substantial evidence in the record. It's interesting, last week, LUBA, the Land Use Board of Appeals, issued an opinion in a case that's almost the same as this one. It's called Brett versus Douglas County. And not surprisingly, it went down exactly as I said it would, and that is LUBA remanded on 4 of the 5 assignments of error. on some of the same issues that we're talking about today. Not enough sampling of aggregate to define a representative sample. It's the same problem they had. Now, here they went back after I told them that and dug up some more samples. I still don't think that's a representative sample because the amount of aggregate on this site is not a uniform layer. So it's a lot more sand, and you can testify to this. There's a lot more sand on the southern half of the site, a lot more of the good gravel on the northern part of the site. Luba said there was insufficient information about the conflicting uses and predicted conflicts from mining. I've been beating that drum pretty hard here, and I think we'll get the same result. Non-existent discussion of noise and dust impacts on adjacent homes and adjacent agricultural practices and adjacent mining operations. There was a failure to conduct an adequate ESE analysis. Interestingly, Luba had a discussion of what it means to minimize a conflict, and they looked to the definition in 660.023.0181G, which says to reduce the identified conflict to a level that is no longer significant. That's what the task is here today for the applicant. And in cases where the types of conflicts are addressed by local, state, or federal standards, such as DEQ standards for noise and dust, to minimize the conflict means to minimize that to ensure conformance with the applicable standard. Now here, in this case, there's been no effort at all. There's no evidence at all on noise conflicts. There's just nothing in the record except for the letter that I submitted yesterday from Kerry Stanley, who's an engineer at DSA, who's done 350 gravel pits all over the state of Oregon. And he says the applicant has not taken the steps necessary to demonstrate the conflicts are minimized, which is a pretty obvious conclusion since there's no evidence in the record at all. All he said is we'll build a berm. Don't say how high the berm's going to be or how thick the berm's going to be, or is it 3 feet or 30 feet. They don't say. And then they even said, well, we're not going to put a berm in front of one of the houses because the person that owns the house doesn't want the berm, which is, of course, irrelevant. But so in this case, I think it's absolutely obvious that the case should be denied or the record left open for the applicant to submit more evidence. But I'm not asking that the record be held open. There is a letter from Dr. Lynn Green. It's one of the preeminent geologists in Oregon. This letter discusses the effects of chemical dust suppressants on things such as air quality, groundwater quality, and quantity. One of the things he concludes is that if you use dust suppressants on your gravel pit, there's likely going to cause an effect of failing to recharge the groundwater aquifer. Now, this is called the Butter Creek Critical Groundwater Area. It's designated by the state of Oregon. And the applicant, if they're going to use chemical suppressants, which is what they say they're going to do because they don't have any water, will require approval of that. And it's unlikely to get that approval because of this groundwater area. So anyway, I submitted a letter yesterday where I went into greater detail. Because you only want 10 minutes on each person, so I will leave my comments at that. I would like Wade Jr. to talk about the way that you guys do dust suppression using water and how many trucks a day that you use to water down your haul roads.
For managing haul roads, we have an off-road truck that hauls 10,000 gallons. Okay. With our site that we're currently using right next to Coleman's, there is about an 8,000 gallon water truck that is watering that road about every hour to keep that managed. And that's water that's available on site every hour. And then on top of that, for about an 8 to 10 hour shift, it takes about 5,000 gallons of water to manage the dust quality on a crusher. Depending on the setup, it could change the numbers, but that is what I do being laid right adjacent to a freeway. I use excessive amounts of water to make sure that I manage my site. And my issue is I don't know how we're going to be able to manage something that has overburden removed right adjacent to my site and blow into my site, it's going to be hard to manage my water. If you're in a windstorm, that dust blowing into my site is going to make my site dry out as well, and it's going to be a big dust bowl right along that freeway. Now, are you going to say when that windstorm comes, are they just going to pump their agriculture water into a truck and do it so that way the phone call don't happen? I don't know. Okay, I can't make assumptions. But what I'm saying is, how is that going to be managed legally using that water the way it's supposed to be used to manage that? When you remove that overburden, it's going to have to be watered. It's blow sand. Are you going to spray it with chemicals and do dust with chemicals on that overburden? How is that going to affect the concrete rock? How's that going to go with how it responds to forming concrete? Nothing has been laid out to where that we know that can be used that way. Okay, the only way I do it is with water, because water is available to me, and that's what I know, that it's not going to affect the concrete, it's not going to affect the farm, it's not going to affect anything. That's the way I manage it. So it leaves a concern knowing that there's going to be ground scraped and remove the surface right next to my pit, and I don't have no confirmation that there's going to be adequate amounts of water that is going to be used to keep it down, especially in a sand area. So.
Questions?
So, how big is do you have a water right then that you're using to water that?
Yes.
How big is your water right?
I don't know the answer to that question, sir. I'd have to pull up the records and look. I do know that it's the number one water right in the state. I don't know how much I have. I have 4 wells on that site, and I'm pumping 350 gallons a minute into that water truck. That's what I do know. So I'd have to get with Bill and talk about this. I've recently taken this over from my dad. My dad's retired, and I'm learning all these things every day. So.
Thanks, Commissioner. Commissioner Timmons?
Yes, I have two questions. One, is your water, is that ag water? It's an ag water?
Commercial. It's commercial use. So I had to transfer that. I had to transfer that process into commercial use to be able to use that. I can't use my farm water to do that. That'd be illegal.
Yeah, that's the problem that they have right now. The applicant has, and didn't realize that until the hearing happened in front of the planning commission, and the water rights, the water master told them, yeah, you can't use irrigation water for industrial purposes. You have to switch it over. You have to transfer it. And there's some problems with that too.
And I did all my transferring before I chased to get mine approved. I transferred all my water to where I'm doing it right. It's an all or nothing game. If I'm going to be next to that freeway and I'm going to be playing this game, I got to ditch that part of, I'd like to farm everything while I'm doing it too, but I have to ditch it and focus on what I'm focusing on because I'm committing to it. We're talking about being right next to people that drive by here that don't care about me, and if something happens to them, that's my livelihood.
So, Mr. Aylett, all 4 of your wells then are industrial use?
2 of them.
2 of them are industrial use?
Yes.
Okay. And then the other 2 are agriculture?
Yes.
You've kept them as agriculture, okay. My other question is, back to you, sir, is that you said it was unlikely that the Butter Creek critical groundwater area, as far as water, would give the applicant any, there would be problems there. Have you contacted them?
No, there's a letter from my geologist, and what he's saying is that if you were to put chemical dust suppressants in the bottom of that pit to control dust, that what's going to happen is that when it rains, that water is going to pond up. And he told me they had cases where his own clients were using chemical dust suppressants, and every year they have to redesign their water detention facilities because they don't work, because the rain takes all the chemicals into the pond, settling pond, lines it essentially, and then no water can get through it, so they have to dig it out every year. It's a big problem. And he said, he was saying that it really is bad to use these chemicals because once you start using them, you create a big pond essentially. It's almost like putting a bentonite clay liner in the bottom of a pond. It makes it to where the water won't infiltrate. And then it starts evaporating, and when it evaporates, it doesn't get back to the groundwater.
Okay. So is this an industry standard to use this chemical suppressant?
No, this is what they've proposed because they don't have any water. Now, they haven't told us anything about the type of chemical they're using, which is one of the problems with their case. They just says, the only evidence in the record is hey, we'll use dust suppressant, we'll use chemicals. They don't say what kind of chemical, they don't say how often they're going to use it, they don't say how effective it is, they say nothing. And
They
that-
also used, well, there's a pit across the road that doesn't have water. So it'd be unfair for them to be allowed to have, not have to have water and us too.
And that pit owner's here, and he's basically saying that he does have water, right?
Testimony? I don't remember seeing that.
It was brought up by H&S. And what I'm saying is basically, it'll probably be brought up again, is that with them sitting across the freeway and I'm sitting on the other side of the freeway and they're sitting on this side of the freeway or on the other side of me.
My question, Mr. Aylett, is we have to go by the testimony.
Okay.
So I was wondering where in the testimony they said that there was a pit across the street not using water.
Okay, it was in a hearing, and all I'm testifying is that you got to handle it different because you're going to be stacking somebody right beside me. I'm going to be here, and this guy's on the other side of the freeway where the prominent winds don't blow. So I'm just trying to say that it does affect me, whether someone says it does or doesn't.
So I guess to finish up, what I wanted to say was the chemical suppressant, because we don't know exactly the product that's being used, we don't know what it's going to do. So
Which is why you should deny it.
So we cannot assume what's going to happen with that water because we don't know exactly what type it's going to be used at this point.
And it's the applicant's burden to prove that there's no conflicts or that conflicts are minimized. So in the absence of information, you have to deny. It's really that simple. That's exactly what that Luba case said. I mean, 4 out of 5
We
assigned.
will be the adjudicators.
Okay, well, no, ultimately Luba is the adjudicator. You make the original decision, but the
That's
state.
fine, and that's what we're doing today.
Right.
Okay.
But I'm telling you how to make a decision that'll survive
You
Luba
need to
review.
tell us how to make a decision.
Okay.
Thank you. Commissioner Timmons?
I'm done, thank you.
I have a couple of questions also, Mr. Stamp. The first one's on the noise from Carrie Stanley, and I don't, she's not on today?
It's a he,
He?
and no, he's not here today.
I guess from your comments that, we just got this yesterday, so it was tough to get review done, so it was basically a Google search. But you mentioned that he had done 350 noise tests in Oregon.
Well, in Oregon and across, that might include Washington as
I
well.
think the majority of them were in Washington, and is the standard the same in Washington?
Very similar.
So it's not the same.
I'm an Oregon lawyer, so I don't know the ins and outs of Washington law, but I do know that all these standards, I mean, in all states are very similar. The DEQ standard that Oregon adopted wasn't really an original standard. It was originally adopted by the EPA in the 1970s, and most states kind of said, well, the EPA, that's what they think, so we're just going to adopt that. So there may be slight variations in the actual dB limits from state to state, but they're very close. But in any event, Mr. Stanley's done, I mean, I think he's done more than anyone else in the state in terms of noise studies for aggregate pits.
I mean, his
Yeah.
previous company.
Yeah, DSA, he still uses the DSA name. He had a bigger company and he retired and sold that, I think, but he still, I guess he decided retirement life didn't suit him, and so he's now still doing work. So I was happy to be able to get him on board. And he wrote the memo using the DSA name. So I haven't talked to him about how all the ins and outs of that, but But needless to say, I mean, he is the preeminent acoustics engineer in the state of Oregon when it comes to gravel pits. And I cited in my materials 3 LUBA cases that accepted his evidence as substantial evidence in the record. So, I mean, he's the real deal.
Thank you. So my question goes back to the same as Commissioner Schaefer and Commissioner Timmons. Then we move on, is that the bottom line is that for the applicant to get a permit, they'll have to go through additional steps, whether it be water or other issues. Am I correct?
Yes, sir.
Okay. And it's chemicals, there's polymers, there's synthetics, there's a whole wide range of chemicals besides lignite and calciums and bituminous-based chemicals that can be used that don't have the effects that you discussed. Isn't that correct?
They all have effects, and they all have costs. And part of the reason that the chlorides are the most commonly used in Oregon, and that's because they're the cheapest. But they have definite effects. You're putting salt in the ground.
Not all are salt-based.
That's true.
Polymers, synthetics have 0 salts.
So that's true, but they're also much more expensive. And when you're talking a 200-acre site, you
But
quickly.
again, we're not in charge of the operating profits or losses of the applicant.
That's true, but you have to show that it's feasible for them to accomplish the goal of mitigating impacts and impose conditions of approval that require them to do the things that they say they're going to do. And they haven't really even told you what they're going to do. So I don't know how you would even do that. I mean, they haven't given you enough detail to even formulate a condition of approval. I mean, the condition of approvals need to say something like, you will apply chemical dust suppressants 5 times a year, something like that. And how do you know whether it's 5 times or 4 times or 3 times? You don't have any evidence in the record to say how much is going to be sufficient to accomplish the goal of ensuring compliance with the DEQ standard. And that's exactly what that LUBA case said last week.
Other questions or comments? No. Thank you very much. Additional opponents? Seeing none, I'll call comments from public agencies. Yes. Oh, I'm sorry. Neutral? Neutral, yes.
I don't have any comments from agencies.
Okay.
I have neutral.
Neutral. Thank you.
Okay.
Yes, please come up, state your name.
I'm Bree Van Cleve, Stone Ridge Contracting, 33228 Oregon Trail Road, Echo, Oregon. I'm a have a chair. Okay. I'm a heavy civil contracting project manager for I'm the area manager for the Boardman projects. I work for Amazon directly, and I buy a lot of rock. So I'm here supporting fair competition and making sure that you guys know that there's support for more rock in our area, and there's a need for more rock. So, as you know, it's public knowledge that there's 100 buildings going in our area in the next 10 years, 100 data centers, and we're gonna need the rock for concrete and base and foundation, and I'm here to say that we need some fair competition in that area, and we only have one rock pit.
Okay, thank you.
Yep.
Neutral?
Thank you. I'm Terry Clark, 1325 Northwest Warren. And I'm speaking neutral. I do have one comment in regard to a comment that was introduced in December 29th by Carl McLean regarding water rights on an adjacent source. I am a partner in that source, so you have a
Sure.
letter.
Thank you,
I
Craig.
missed the deadline, so it didn't get included.
Thank you.
We do have water rights. We are using water for dust suppression as well as other means. We're an asphalt paver, so a lot of our roads are paved, so.
And where's your property, sir?
We are
Next to the livestock.
next to the livestock sale yard.
Okay.
But I've spoken at several hearings in a neutral position, but mostly my concern is the lack of data, or lack of information to make any kind of informed decision. You know, I looked and the completeness, and so I pulled the Chapter 660, Division 23, goals, and 3, 5, and 7. And I didn't know if you had ever looked at those. I made a copy. I didn't only make one copy.
That's fine.
And I'd like to go through a couple little pieces there that I'm confused. I could be totally wrong, but I'm thoroughly confused on it. Section 3 was the first reference.
Is this a question to staff?
No, it's directed to you
Okay.
because it relates to my comment that incompleteness would allow you to make an informed decision. I don't see how you could even say it conforms to the comprehensive plan without the data. So item 3 in here, the first one that the staff recognizes, speaks to the volumes and the quality, and the applicant has made an attempt to do that. You know, I don't know the adequacy, but they've made that attempt. 5 gets into it a little further, and down in 5, it refers to the first paragraph. Now, read that. For significant mineral and aggregate sites, local government shall decide whether mining is permitted. For a PAPA application involving an aggregate site determined to be significant under Section 3 of this rule, the process for this decision is set out in subsections A through G of this section. A local government must complete the process within 180 days after receipt of a complete application that is consistent with Section 8 of this rule, or by the earliest date after 180 days. Section 8, if you get a chance to flip back there, determines that there's all sorts of data that they need. They've done traffic assessments, they've done some proposals for properties or complexes within 1,500 feet, but in that there is also a site plan criteria. And you don't have a site plan, you have pictures, but you don't know in that site where they're going to mine, what they're going to mine, what kind of depths, how it's going to be reclaimed. You don't know anything about it. Only 75% of the footprint could be mined. So which 25% is going to be set back? You know, because of the size of the site, it's a lot more than what's in the 25-foot setback on the other. So we don't know enough to make a decision. We don't know where the haul roads are. Now we know today where the plant will sit, right? And how they're going to get there. We don't know any phasing. We don't know anything. And so how the planning commission could even make a determination that the comprehensive plan criteria will be followed. There's not enough there. And that was the crux of where I was going with this. The other thing is the approach. When you look at the subsequent, where are my notes are, at the conditions imposed or suggested to be included in the finding, this is the last opportunity, the only opportunity that local people have a representation. You know, the planning commission and what happens there is the last thing that happens. From there on, it goes to the agencies. So say we're gonna let the GAMI determine what their reclamation plan is. Well, that's great, but you have the opportunity to impose conditions that are reflected only by the local concerns. The dust control, the residence that's next to it. You have the ability to impose conditions there that are specific to that location, depending upon prevailing wind, the weather conditions, traffic, all of that. But yet there is nothing there to do that. There's nothing about screening. There's a total lack of local concern. And I can't believe our process has gotten to this point. You know, we have to have local input. That's the whole purpose of the planning commission. You have to have that right to impose some things. Maybe you are going to follow what DEQ and Delgamy say, but they don't live here. You know, they're complaint organizations. How many times would a local citizen, say the guy living next door, would he be willing to call DEQ? Well, most everybody's afraid of DEQ. I'd rather call the county commissioners. And you have nothing to fall back on. There's a total lack of local input or local concern in what we've got. So, yeah, that's my concern.
Thank you. Thank you, Mr. Clark. Any other neutral comments? Back to public agencies. Call for rebuttal. Proponents' opportunity to rebut testimony. Again, reminder of the 10 minutes.
Yep, thank you,
On
Mike.
file. Thank you.
So again, Chair Doran, Commissioner Schaefer, and Timmons, thank you for the opportunity. Carla McLean for the record. Lots to unpack in that, but again, most of it has been addressed. It was addressed at the Planning Commission level, and staff have adequately summarized that and amended conditions as requested by the Planning Commission. And you have before you here a request that does comply with the standards, will be regulated by state agencies as well as the county, and you have no fewer than 15 conditions that have been applied to the operation and how it will operate and what it will do. Water rights, again, we've addressed that. The applicant has every intent to initiate that process with Water Resources, working with his consultant to do that once this application is in hand. The opponent identified that not all of their wells had been transferred to commercial or industrial use, so it's a process that takes time, and it's a process that has some effort behind it. But the conversations have started with both Water Resources through the applicant and the consultant. Use of water versus use of chemical dust suppressant. Both are standards in the industry. Both work, both have problems. But the operational considerations are the operators, and the regulations would be applied by the appropriate state agency. The site is not within any of the critical groundwater area that was identified by the opponent. It's outside of those designations. It's too far to the east to be inside that. Lack of data. I apologize for a record that's 478 pages long. That's a lot to get through. The standards are, I found in Oregon Administrative Rule, the same standards that you've seen in rock pit approvals that have gone through the Goal 5 process for a number of years. They've been static rules. There hasn't been a lot of change to them. There's a pretty big legal case probably 20 plus years ago that really kind of finalized the rules that we operate from today. So the pits that you see, Mr. Aylett's pit adjacent was approved under the same rules. Other pits in the region have also been approved under these rules, or rules that were similar. Yeah. Anything you would want to add?
You know, the one thing that I will add, the water seems to be a point, and the water and the dust suppression. Okay, everybody's pit, I'm sure, is running differently. Everybody uses the resources they have. Water, we have a 1,400 acre farm there. We have permitting for over 10,000 gallons a minute. The process that we've followed per Bill Porfilia, our water rights examiner, is until you have your county permitting in place, there's really no reason to go out and start the process of changing water rights from ag to industrial because it's a long process. There's really no reason to start that process until you have something in place. Because once the process is started, I can no longer use that water for ag. So we will, on that, just on those pieces right there, that's 120, 104, 160, about 180 acres there. We're permitted for approximately 800 gallons a minute for ag. And as the ag goes away, that water becomes available for industrial. It's not an overnight process. We understand that there's other ways. There's limited licensing. There's other ways to do it. We have identified if we get started before water has been transferred, or the state has let us change from ag to industrial. Excuse me. There is industrial water that we have in the application that we have identified. Portomoro sells water all the time. Yes, it's a little bit farther away, but that is an economic decision that we make, not our competition. We'll skin our cat, however, under the laws and the rules that we're supposed to. That's about it. The one thing I did want to mention is we're not in the Butter Creek critical groundwater areas. That's actually in the ordinance basalt and ordinance gravels. But it's on the east side of that. And we do not recharge in that area because the water, there's a clay layer there that will hold the water in place. If you go to the west, about 3 miles, water falls through the sand. We do it all the time, every year. That's how we get our water for that farm, is this County Line Water Improvement District. And that's where some of the water for Aylett's Pit on the west side comes from, is a limited license through County Line Water Improvement District. They also have the ag stuff too. But water seems to be one of the issues that we have here with dust control, and rules are rules. We follow them when the time comes. That's all I have. Thank you.
Thank you.
Happy to answer any other questions you may have. We didn't get any in the first round, so just want to make sure if there's any, we could get the answers out there.
Actually, I did write down a few questions. You answered most of them.
Okay.
I'm a big water guy, and so.
We all are if we live here.
Yeah, right. As you well know, Oregon has 7 critical groundwater areas.
Yep.
4 of them are in the Hermiston area.
Oh, I'm well aware.
So that's a big concern for me, is do you have enough water? And, and like you said, sir, when you take the water from ag and put it into industrial, it doesn't go back to ag. And we're an ag-based economy, so that's my concern. So that's one of the things I was gonna ask you about, but.
Yeah, I think we only want to transfer the water we need to transfer so we can maintain the agricultural operations. I mean, it's important. Mr. Coleman has a large farm and he needs to figure out how to manage all of the resources that he has, that he can obtain, and how he inputs them to get the maximum output.
It won't be an easy hill to go up to get water rights transferred, just so you know.
Oh, yeah.
And I'm sure I'm not the first person to tell you that.
Yep.
So, okay.
Mr. Tim?
Yeah, I do have a question. The dwelling, the tenants that live in the dwellings, have they been contacted?
So
They're here. They're here, okay. I would like to hear from them, honestly. I don't know if this is the way we do business, but I would like to hear what they have to say. So thank you.
The question that I have, and we'll get back to it. The question that I have is on the transportation plan. And
Sure.
the Center Street Road, even after reading the transportation plan, I wasn't clear on how that's gonna be integrated or transitioned into the program.
So Center Street was platted in 1910 on an old plat. It sits right in the picture you're looking at. It would sit north of tax lot 1800 and south of the 2 other tax lots. So where the leg is, I guess it looks like a P when I look at that up there. So, at the bottom part of the upper half of the P. It goes out and connects to Colonel Jordan Road. We have requested, you have approved vacating that road within Mr. Coleman's property. But the applicant, based on conversations with Tom Fellows, who is the Roadmaster Public Works Director, has identified a gravel standard to get from the edge of Mr. Coleman's property, actually along the border of Mr. Coleman's property out to Colonel Jordan, improving that road to a gravel standard, industrial gravel standard. He's asked for 100 feet of asphalt at the intersection with Colonel Jordan to protect gravel from moving onto the county road. The intersection then becomes a full intersection with Noble, and Center Street's name goes away and it becomes Noble Road. So Noble Road gains about 3/4 of a mile here with this proposal. It's a dedicated public road. It will continue to function that way. Others who are adjacent to it could take access to it if they so chose. The traffic impact analysis that was done was an evaluation of the interchange because it is it's the protection of the interchange that is the objective of ODOT and the transportation planning rule. And so the evaluation was the impact of the interchange on and off ramps based on both, I think it was 2022 and then 2042 were the years that were analyzed in there. And there was no change in level, no discernible change in level of service based on that, with the traffic that was identified being associated. And again, not only with the pit itself and the traffic it would produce, but just the regular growth that would happen at that interchange. And interestingly enough, when you look at the last 20 years of that interchange, it's actually a very interesting bell curve. And the peak was actually about 10 years ago. The traffic at that interchange has actually been less the last 10 years than it was about, so it's just really interesting bell curve that you see. So who knows what's going to happen with that interchange going forward?
Okay, back to the question.
Okay,
So the transition from Center Street to Noble Street will happen upon the initiation of operation?
That's I think more of a Tom Fellow question. My understanding is that when the road becomes a road, the road name will continue to be Noble. And maybe your planning staff can provide some better insight into what the intent there is. My sense is that based on the decisions that have kind of been made, it's already Noble Road.
And just one last clarification, my understanding is that's our only access.
Right. And that's what I was
So
trying
there's
to
no
get
other
at.
way, no other place to
Is
go.
what- That transition doesn't happen until operations are in place.
Right.
Yeah.
Is that, Megan, is that your
Yeah,
interpretation?
and I believe that's one of the conditions of approval. That they work with the road department to bring it up to the standard.
It's condition
Yeah,
12.
The mining operation is restricted from utilizing Stafford Hansel Road, and access for the mining operation shall use Center Street to be renamed Noble Road.
Okay, so to me, my interpretation is that doesn't happen until operations start,
Before they start,
or before they start,
Yeah.
but once they're approved.
yes.
Okay. Other questions? Let's go back to Commissioner Timmons. Was there a willingness of the neighbor to testify? It doesn't look that way.
We won't put you on the spot, I promise.
Are we done? Or-
Yeah, you guys are done. Thank you.
Thank you.
Names and address, please.
Wesley Walker, 28286 Stafford Hansel Road,
Thank you.
Hermiston.
Thank you.
I'm Shelley Walker, same address.
Thank you.
My question is, everybody talks about you, but you haven't had a chance to say anything. And so, on both sides. So we just wanted to know what
Well, as you can see, we're kind of stuck right in the middle.
you are.
We've lived there 14 years. Craig Coleman has been an excellent neighbor. And what he tells me I take to heart. He says that we won't have problems with him. But down the road, does that mean he sell out in 2 or 3, 5 years, and then we've got somebody else to contend with? We don't know. What happens to the value of our place once a rock pit goes in next door? I don't think you people want to be living next to a rock pit, having your home there. Maybe it's not as bad as I think it might be, and just small concerns like that. As the value of our place dropped 50%, and at our age, you know, we don't work anymore, so what we live on is what we got, and the value of our house is, in a way, our retirement too. So we're kind of sitting back in the shadows here to see what you guys are up to and what's going to happen. And, we're not trying to raise a stink about anything. And like I said, I've been real happy with the Colemans, and I don't think they're trying to pull the wool over our eyes, and I don't think they're trying to do it to you either. So that's that.
What about the berm?
The what?
The berm? Are you the tenants that said?
Well, yeah. If you noticed down the road at Rockets, there's a 40-foot high berm runs all along the road, and I don't want that in my backyard, because one of the advantages of our place is to see the foothills and stuff out our back. I don't want to be looking at a pile of dirt. So that, and Craig said that there wouldn't be a berm there, and we'll see what happens, I guess.
Do you want to add anything?
We're gonna do what's gotta be done. I mean,
Anything else? Thank you, guys. Thanks, Mr. and Mrs. Walker, for being here today. At this time, I'll call for requests for continuance or to keep the record open. Seeing none or hearing none, I'll move to close the hearing. Hearing is now closed, and we'll begin our deliberations as the adjudicators of the request. I'll open it up for comments. Commissioner Tillman? Commissioner Schaefer, you want to start? Oh, go ahead.
I'm sorry. Were we gonna have an opportunity to hear from the? Okay.
I don't have anything.
Comments, Commissioner Timmons?
I appreciate everybody being here today. I was at the first, of course, I said I was at the October hearing, and yeah, it was heated. I will give you that. So I very much appreciate everybody today and the good information. There's been a lot of information, that's for sure. And I appreciate just the facts. I guess can I ask just general questions? My general question, and I guess this would go to planning, is the application complete?
We deemed it complete when we began processing it, and when the planning commission made their recommendation to approve it, they also found it to be complete. And that was the
So the application is complete, okay. And does the application meet all the criteria for a permit?
That's what the planning commission found, yes.
That's what the planning commission found, okay. And the one comment I wanted to make to Mr. Clark, I appreciate very much you coming today. I guess you talked about local input, and I think that's what our planning commission is. They're local citizens, they deliberated a long time, that's what we are. You know, it isn't like we got this yesterday. I mean, we've all read the material and, so I appreciate what you said, but I think that as far as a local voice, I think that's exactly what you're getting with the planning commission and then with the commissioners. But I appreciate your comments. Thank you. That's all I got.
I'd like to take a moment first to thank our planning commission. They put a lot of time into this. And if you read through the minutes, they put a lot of deep evaluation of all of the information presented. There was obviously, even the tone of some of the minutes, that it was contentious at times, obviously. Again, when I started the meeting today, land use is an adversarial issue at times. And the one hope that I have is that everybody walks out of here as neighbors, no matter what the decision of this commission is. And that everyone realizes there's been a lot of time put into this issue. Sand and gravel is not gonna go away. As there's been a lot of discussions. You don't have to go but 3/4 of a mile and you're on another county's property. They're gonna have the same issues that we're dealing with today as they look at access to material and inventories. I can guarantee you places like Seattle, Tacoma, Spokane, Portland are envious of our resources that we do have, and that some of those newer high rises someday are going to be built out of sand and rock from this area. There's no doubt in my mind of that. In fact, some of them already are. But again, it is contentious, and our job here is to look at, first of all, with all respect, the Planning Commission and their deep dive and their review and their paralleling this to what the criteria is for approving the request to be a Goal 5 overlay. And I respect their decision. It was, I think the last one was unanimous, but it was 7-1 before, and I put a lot of respect into the time that they put into this, the time that the other two commissioners put into reviewing this document. And so I have to be honest with you, I have not found a deficiency in the application with the criteria stated. What is the wishes of this commission?
Well, Mr. Chair, I too looked at this and I couldn't find any deficiencies. That being said, I would make the motion to approve the Girth dog gravel pit.
To adopt the findings?
Yes.
Perfect. Is there a second to that motion?
I second. Do we need to put in some amendments? Or
What was that, Doug?
We do need to, at some point, accept into the record all of the exhibits through our.
That's true, yeah. Let's do that first, I'm sorry.
Okay. Need me to withdraw my motion then, Doug, to do that
I
first?
think that's still pending. You can go ahead and make another motion.
Okay, because there's not a second.
Okay. Oh, she did second it.
Oh, she did?
Yeah.
Then can you
You
leave
can do it
that?
in both.
Can we leave that pending? I bet A days are kicking in.
that's what I'm thinking.
Yeah.
Okay, I'd entertain a motion to accept all of the presented evidence today at this hearing.
Second.
Oh, no, so moved.
I'm
Did you make
entertaining.
the motion?
No, he's entertaining the motion.
Oh,
Did you want to make the motion? You
yeah,
wanna
I
make
can, yes, so moved.
it? Second.
All those in favor?
Aye.
Motion passes, all the evidence is accepted into the record.
And that intent was to include all the exhibits up through our.
That included all. Yes.
Oh, apparently through T,
Terry Clark,
S and T.
S&T.
Excuse me, through S and T.
Right,
Okay.
those are what we accepted, yes.
Yeah, what she said.
At this time, I'll go back to the motion and the second to adopt the findings of the Umatilla County Planning Commission. All I got the look.
This is a de novo hearing, so you're not just taking you're doing your own decision. So if you want to adopt findings, approve and adopt findings for that decision, that'd probably
We
be.
don't have to do those individually, right?
No, you go ahead. One motion's fine.
Perfect. So there's been a motion to adopt the order with the criteria spelled out, and a second. All those in favor? Aye. Thank you very much. Again, thank you to everyone today, and the meeting's adjourned.